Okay, having shut my filming off sua sponte again, we will pick up with part 3 of Notes 5. We're still talking about partnerships, and hopefully this will be the end of Note 5. We'll hopefully get it all on this video. All right, we had been discussing the termination of partnerships, and we had said that partnerships can be terminated by agreement, by completion of purpose, by end of a fixed term, by operation of law, or by judicial decree, right? If a partnership has in its members or its employees, agents, have engaged in illegality, there's no way to really punish a partnership because it doesn't exist as a separate reality. It is made up of the partners. The partners certainly can be fined and can be subject to criminal prosecution individually for any of their activities. But one of the things that a court can also do is to terminate the partnership as a punishment for violation of criminal law or for other illegality. A court can also terminate a partnership for something called impracticability, which is a legal concept out of contract law that says the reason why we entered into this contract has now become unworkable, unusable. There's no financial incentive or value or benefit left to it, so we might as well just wrap it up and terminate it. And remember, a voluntary termination would take a unanimous consent. So you have a situation where the partners believe, or the majority of partners believe, this is no longer worthwhile. We want to terminate it, end it, finish it. And you have a couple of partners holding out saying, no, we don't. If the majority partners can prove, or even a minority of partners can prove that is impractical and financially purposeless to carry on, then the court can terminate the partnership. Now, a duty of good faith is imposed on all partners in the termination process. And actually, a duty of good faith is contained within the fiduciary duty, so that the duty of good faith exists at all times during the partnership relationship. But good fiduciary duty is actually stricter than a good faith duty. So when we say fiduciary duty, we are implying that good faith is in there. Good faith is the idea that you will tell the truth, you will behave honorably, you won't lie, you won't conceal funds, you won't conceal property, you won't conceal facts as to the reality of what's going on, but it's a little bit less duty than fiduciary. You can still be looking out for yourself, looking out for your own interests, but be proceeding in good faith. So once the corporation is dissolving and once the partnership is dissolving and is in termination, the partners no longer necessarily have a fiduciary duty to each other, but they do have a duty to perform in good faith, which means that they would have to make all information they know available. They would have to not deliberately do things to injure another partner. They could worry about their own interests, but they would also have to be careful not to injure or damage the interests of the other parties, or the other partners. After a partnership has terminated, it enters into something called a winding up period. And what happens in the winding up is that the partnership may still be selling things. It may still be doing the books. It may still have tax returns to file. It may still have contracts to fulfill. Even though they have terminated, there are still activities that may have to be finally resolved, and so the law provides for this period where we have officially terminated. No new things are going to happen, but it's going to take a period of time to undo what is existing. This can run for some period of time, and the statute set certain time parameters for different parts of the winding up, and sometimes it can go out as far as, I know under the corporation statute in Rhode Island, it can be considered to be in a winding up period for almost a period of 10 years at this point. Any partners who are working on the winding up, who are working on resolving all these final issues, have a right, again, to be compensated by wages, by hourly salary, by independent contractor agreement for the time and expenses that they incur in this winding up process. The final part of terminating the partnership is distribution of assets. All right? And there is an order set by the statute, and it had been followed by the common law previously, but it's basically this. First and foremost, any assets of the partnership go to pay debts to creditors or monies owed to partners who may have loaned money to the partnership or may have expenses they incurred on behalf of the partnership for which they have not yet been reimbursed. So they would be paid first. Then capital and any profits remaining would be distributed according to the partnership agreement. And if there are not enough assets, if there are insufficient assets to cover the debts to the creditors and the funds that need to be reimbursed to partners, all of the partners have to contribute to that. They all have to put in money to cover the shortfall. And again, this is one of the major downfalls of a partnership, is that you are individually liable. Your personal financial reality is held responsible for the partnership contracts, the partnership torts, and therefore you can end up not just walking away from the partnership and say, well, I lost money on the partnership and nothing else, but your own personal assets could be called to cover partnership activities. There are something called buy-sell agreements, which partners can enter into. It is basically an agreement made in advance which programs the termination. And it sets out the rights, the duties, the way that assets will be distributed, how contributions will be made if there aren't enough assets to distribute or to pay all the debts. And again, very, very many people who enter into partnerships today, right at the very beginning, they'll also enter into a buy-sell agreement that determines how a partner would disassociate or how the partnership itself would be terminated if things came to that. And as with contract law, the law is very easy here in the sense that there are many things you can do, but if you just do nothing, if you go into this blindly, then the statutory fallback or the common law fallback is basically a legal program for dummies. You weren't smart enough to think about this in advance. We, the court, we, the statutory setup, have a way for dealing with it. Same thing is true in wills and trusts. If you do not make a will, the state and the courts don't worry about it. They have a scheme for paying your bills and dividing your assets. It may not be at all what you wanted to have happen, but they have the program and they will just run the program through if you weren't bothered enough or smart enough or diligent enough to take care of it while you're alive and to make your desires known while you are alive. The law allows you, under a will, to decide almost anything you want about your assets today, but for those people who just choose to not be involved, not to worry. The law will come in sometimes with a sledgehammer and just follow the statutory rules. All right. Last part of this segment. Distinguishing limited liability partnerships and limited partnerships from partnerships, or what we often call general partnerships. A limited liability partnership is really a quasi-corporation in my mind. It is a statutory creation. It's usually used by professional people, doctors, lawyers, accountants, architects, folks that have to have licenses in order to practice and do what they're doing. And it basically sets up a partnership shell in that there is limited liability. The partnership is responsible for torts and for contracts that were created as a result of the partnership. The partners are not responsible for the actions of the other partners. However, when it comes time for taxation, under federal and state law, these are looked at as being pass-through entities, so there is no double taxation. All right? A partner is always responsible for their own negligence, their own breach of contract, but only the partnership would be liable additionally, not the other partners. In states not Rhode Island, there is also something called a family limited liability partnership. And this is primarily utilized to hold family farms together and to pass them down to the next generations. And in many states, particularly in the agricultural belt in the middle of the country, these partnerships are given special tax status, special tax realities. And I am not a tax expert by any stretch of the imagination, but my understanding is that under federal law for inheritance tax purposes, there are different things that you can do to mitigate the inheritance taxes. Because one of the things that was happening in the 70s, 80s, and 90s is that inheritance taxes were applied at very low thresholds. If you had a family farm of several thousand acres with all the equipment and the bonds and the buildings, you were easily over that threshold. Father, mother would die, and then the kids would find out they owed several $100,000 tax obligation in inheritance taxes on the farm assets, and very often it resulted in these family farms that had been held for generations having to be sold to pay the inheritance taxes. So the federal government, realizing that that was an issue, and the state governments wanting to preserve family farms, created this type of a partnership that can give special tax recognition to preserve these farms. As I said, I don't know that this exists in Rhode Island. I do not believe it does, but it is fairly common when you get out into the Midwest, where farming is a large part of the economy and also of the cultural, social base of those states. There is a thing called a limited partnership, right? And sometimes you may, if any of you have read extensively in English literature or poetry or business practices, you'll come across an idea or concept called a secret partner or a silent partner. And the legal term for that is a limited partnership. In a limited partnership, you have one or more general partners, and they organize the business, they run the business, they manage it, they control it, but they need money. They need capital to get this started and get it rolling. But there are people who they'd like to invest in this, but they don't want to be personally responsible. So what happens is, in a limited partnership, they can draw up an agreement whereby there will be general partners who will have the same liabilities as a partner in a regular partnership or a general partnership. But then there will also be limited partners whose only liability will be that if the partnership goes under, if the partnership becomes liable for contract obligations or judgments in tort, they could lose whatever their investment was. But just as with a corporation, their private assets would be sheltered. They'd be exempt from the claims of any creditors or any defendants in a tort case. Now, these things have to be carefully created for them to work. Because the goal here is that the limited partners would contribute capital, and they would only have the right to share profits, and if the corporation was ever terminated, they'd have a right to share in the capital distribution of the corporation's assets. But they don't want to be involved in any other way, and they don't want to be liable. In order for this to happen, in most states now, including Rhode Island, you must actually file the paperwork for the limited liability corporation, or for the limited partnership, the same way you would for a limited liability partnership or for a business corporation. And the limited partners have to be very careful. They have the rights to an accounting. They have the rights to review the books. They have a right to a distribution if the partnership is terminated. However, they cannot involve themselves in the management or the running of the corporation. They can't be telling the general partners what to do, and the more evidence that can be brought to show that they were doing that, the more reality there is under the common law and under the statute that the court could rule that they weren't really a limited partnership. They just drew up paperwork to make it look that way to try and protect themselves. But again, they could be stopped from saying they were a limited partner, and they could be deemed a full partner subject to all liabilities if that's how they were actually acting, and the plaintiffs in the case can bring in evidence to prove or to show that. Now, a limited partnership will be dissolved according to whatever terms are put in the agreement when it's created. It can be dissolved by the withdrawal of the general partner. If the general partner withdraws, there's nobody left to run the business, because by agreement, all the others have given up all responsibility and ability to control and maneuver and run the business. If there is a bankruptcy, incompetency, death of the general partner, then the limited partnership dissolves automatically. All right? The death, bankruptcy or incompetency of a limited partner will not destroy the partnership or terminate it, because the only thing that would be at stake is whatever profits were owed and whatever the eventual capital distribution would be, and that's something that can be easily determined by accounting and by reviewing the books. So a limited partner can die, they can go into bankruptcy, they can become incompetent, and the partnership would still carry on because those folks, they were not necessary to run the partnership, to make it work. However, if a general partner suffers one of those situations, then the partnership is terminated and there would be a dissolution and an accounting and a distribution of the assets. All right, that terminates what I want to talk about in Note 5. We will see you again when we go over the Note 6, and here we're actually going to talk about a number of smaller, less utilized types of business organizations. Before, in Chapter 7 and 8, or Notes 7 and 8, we're actually going to get into corporations, how they're established, how they're regulated, how they're set up, and all that good stuff. All right, over and out.